We've got some breaking news for you this hour. Flavio Hlabangwane has conceded to the premeditated murder of his girlfriend Tshepang Pitse. He previously pleaded guilty to dismembering and storing his girlfriend's body in a freezer, but the state rejected the plea bargain and wants to convict him on premeditated murder charges. The gruesome discovery of Pitse's body in 2021 shocked the Protea Glen community in Soweto. Let's go to our reporter Manqoba Mchunu, who's following the story for us. He's live at the Palm Ridge Magistrates Court. Manqoba, quite a huge development. Tell us more.
Well, certainly, Maseko, and you recall, of course, that this is a charge that the state had been pushing, the charge of premeditated murder. This is after Flavio Hlabangwane had pleaded guilty on Monday to murder, and of course, the state rejecting that plea bargain that was read in court, where he had, admitted to killing Tshepang Pitse. They believed that there was an element of planning that went into the murder, and of course, they had then proceeded to start trial on that basis to prove a case of premeditated murder. And calling the first witness who took the stand yesterday, of course, the state closing its case today after Flavio Hlabangwane had made those further admissions in court. And he detailed, Masiho, in terms of those admissions, how he had planned to kill Tshepang Pitse, saying that as early as September in 2021, that's when he suspected and in fact confirmed that she was having an affair at the time in their relationship. And he says that when he then discovered this, Tshepang Pitse had tried to then say to him that they could work it out, but he was very resentful towards her after having caught her. He says that he then started to plan her murder. He went into the internet looking at ways to kill a person and also how to dismember a person. So he admitted those in those new admissions that he made to court today, and of course also saying that it was between the period of the 6th of October when he had then, went outside to buy at the shop, and that's when, after coming back, they had a fight with Tshepang. That's when the murder then happened. He had an opportunity to then continue with his plan to kill her. But I want to get a reaction from the NPA, just how they're feeling with this development. Thank you for joining me. Obviously, as a state, you must be elated. This means that your case is now closed, but it's not over yet.
Indeed, yes, Manqoba, we welcome the attitude of the accused person coming to court and alleviating the pressure of proving our case beyond reasonable doubt in that he pleaded guilty. Let me just correct that. There was no plea bargaining, but instead he pleaded guilty and thereafter made admissions in terms of Section 220 of the Criminal Procedure Act. Then as the state, we accepted, as you have mentioned earlier, the 2 counts of defeating the ends of justice as well as violating a corpse. However, we rejected his admission on the murder charge. Reasons being, as the state, we felt that we are in a position to bring evidence before court, evidence of a probative nature, so as to prove that this murder was planned. Because remember, Manqoba, we risked the fact that should we have accepted the murder charge as it was in terms of Section 51(2) of the Criminal Procedure Act, the accused could have likely gotten away with a sentence of 15 years. So it was our duty as the state to bring evidence before court to prove that he planned this murder. And soon after we have closed the testimony of the first accused, the first state witness, and we are about to call the second witness when he then approached his legal counsel and indicated that he wants to do further admissions.
Okay, so what does it mean now? Obviously, the next step is those arguments for sentencing. What is the state going to be calling for?
Well, the law is clear in terms of Section 51(1) of the Criminal Procedure Act, which is a premeditated murder. The law prescribes that the person be sentenced to life imprisonment unless there are substantial and compelling circumstances for the court to deviate. So it is now our duty as the state to convince the court that there are no substantial and compelling circumstances for the court to deviate. However, it is now in the hands of the court. The court obviously will have to take into consideration the seriousness of the offense, the interest of justice as well as that of society, and the personal circumstances of the accused person in in handing out a sentence that is just.
Okay. Thank you very much, Pindi, for your time. That was Pindi Mjonu from the National Prosecuting Authority, just giving us, her reaction as far as the case is concerned. It has been postponed to Tuesday, the next Tuesday, for those sentencing arguments to be heard here in court. And of course, after that, we then could expect likely a sentence.